Supreme Court. I'd like to go over this slide. I think it's very important because the two things you need to understand during this portion is how a court case reaches the Supreme Court and how they hear it. We've gone over this several times, and what I would like to look at are the two ways down here. This says through state courts and through federal courts. Remember, any court case can be appealed from either side, so it goes circuit, district, state Supreme Court, or district appellate courts, and it goes here. This term, rule of 4, is very important because if 4 of the 9 justices say yes, then a case is going to be heard. The Supreme Court issues the writ of certiorari. This is a huge term, and they often nickname this cert, granting cert. And when the Supreme Court issues this, it is a court order demanding that the lower records be sent up to the United States Supreme Court. A very small percentage, only around 100 out of anywhere from 5,000 to 7,000 cases, are petitioned each year. If the Supreme Court does not accept the case, the lower court decision stands. Remember, this is not the justice's way of affirming the lower court. They just see either issues that are more pressing or it's not a constitutional issue that needs to be decided by the court at this time. If a case goes through this way, this is called original jurisdiction. Remember, the Supreme Court has original and appellate. This process is called appellate. If a court case starts in the United States Supreme Court, it usually deals with something as a state versus a state, or if an ambassador is involved, or the consulates. And so those are the two things the Constitution says in Article 3 that automatically start there. Everything else works its way up through the courts. Let's go on to the next slide. The one that you just saw here, this is just another way of going through the court system. So if we see here, the case is now on the docket, cert has been issued, and lawyers on each side write a brief. A brief is just a written summary of the lawyer's argument, and the briefs are submitted. Also, this term, amicus curiae, which means friend of the court. This is a Latin term, and this is the only way really to lobby the Supreme Court. You can lobby Congress and the president's staff, any members of a congressman's staff face-to-face, but judges are not as approachable. That's not what you do because you don't want to have a conflict of interest. So an amicus brief is a written summary of interest groups and how they believe. It can be an individual citizen and how they think the case should be. It could be family members even of people who have been wronged. And they all submit written briefs, and those briefs help encourage the judges to make one side or the other. After the judges have all this information, they read it, they come up with questions, and then they go to the oral argument. The oral argument is 30 minutes for each side, so it is 1 hour total. And the justices might have 2 or 3 oral arguments a day, but they might only have 2 or 3 days of oral arguments for the term. Remember, the justices' term, each term of the Supreme Court, runs from October 1st to June. This is when they start and decisions are released by June. Sometimes they're released sooner, but in the months of April, May, and June, sometimes major decisions are announced every day. After oral argument, and I'll go over that in a little bit more detail, the justices go to conference, then they write their opinions, and then the decision of the court is announced, and I'll go into more detail on those in the next slides. So let's really look at the Supreme Court in action. Once a writ or a cert, the writ of certiorari, has been granted by the court, the lawyers submit the side, and we have what we call oral arguments. Normally, lawyers, 20 minutes and 20 minutes on each side, and then 10 minutes and 10 minutes are given questions really by the justices. They summarize their main argument, and at any time a justice can interrupt the lawyers and ask questions. And so it's really a way of the justices communicating with one another through the questioning as well as trying to get the lawyer's bottom line. I want you to be familiar with this term. This is called the Solicitor General, and he is the lawyer who argues the case for the United States Supreme Court. Please do not get this confused with the Attorney General. The Attorney General, oops, my pen's going crazy. The Attorney General is a cabinet level official. It's like a secretary, Secretary of State, Secretary of Defense, but this one's called the Attorney General, and they are in charge of the bureaucracy of the Department of Justice. The Solicitor General is your acting lawyer who argues the cases on behalf of the United States. His office also decides which cases that they want to try to get the Supreme Court to consider, so they can also petition the court for cases to be accepted. We've already briefly mentioned amicus curiae briefs. That's the way to lobby the Supreme Court. Once they are in conference is an individual room with a table, and they have all their materials. And once they've heard these oral arguments, this is the first time that they really get to discuss the case as a whole. All 9 are present. The Chief Justice speaks first in order of seniority, and they go around the table. Everybody gets to speak about the case at hand before anybody else gets to speak twice. When they are ready to actually vote, the voting is done in reverse order. So Justice Kagan, Justice Sotomayor would be the first ones to vote, ending with the Chief Justice. If there is a tie, the lower court decision stands. It doesn't mean that they're affirming it, it just means there could be a tie. Remember, in some cases, a justice has to recuse themselves. And what that means is they might have been involved in a lower court decision before they were even on the court. They might have a conflict of interest. Maybe they had worked, or a family member works for an agency or something that is being sued, or they're in the case. Recusing yourself, if one judge recuses, then we'd only have 8 of the 9 making a decision, and it can result in a 4-4 tie. So if that happens, then the lower court decision stands. I've put all 3 of these review videos on the website too if you want to go back. I think it's a great example of the justice actually working and in session having a conversation that you can hear. So I'd like for you to watch that if you have time as well. Once the vote is done, the justices go into writing mode. Now, if you think writing, if you love it, then you would probably love to be a judge on the United States Supreme Court. There are several different types of decisions, so let's go over those. This per curiam is normally done for cases that will not be precedent setting. It might just be involving one individual case. And so they might just issue, we voted 5-4 on this because of this, and it's very brief. Unsigned means it's not going to be precedent holding for a long time. So per curiam, if you ever hear of that, that's just what that means. These next ones are the big ways that you can vote. If you are in the majority, say the 5 and the 5-4, that is known as the opinion of the court, and that will be the one that will carry the weight. The majority are those who agree with the ruling of the case, so they sort of won the case. If you vote yes for the case, but for different reasons, and remember, some of these decisions stand as the rule of law for 100 years, and so these justices might be far gone, but their decision still stands, and so they might file a concurring opinion, an opinion by one or more justices who agree, but for different reasons. And so oftentimes, if you have a controversial case, one judge might say yes for one reason, another judge says yes for another, and they submit those opinions. This last one is called the minority vote, or the dissenting opinion. These are the people who did not win, and the justices want to write why they voted against the majority and what their legal reasonings are. So if you are in a dissenting opinion, you did not win the case, but the justices want to make sure that their opinions are clear, maybe if one day it's overturned. This last term, the AP test loves this one. It's called stare decisis. It says a decision without an opinion, basically meaning let the decision stand. Precedent is what has gone before. So Brown versus Topeka is precedent setting because it desegregated schools. Sometimes the court might just say, we're issuing that, this case be upheld, and so Brown would be the precedent. So it's stare decisis. It's the decision without an opinion because the precedent has already spoken and they still agree with it. The last two words I want to make sure that you're familiar with. Strict constructionists are judges who are bound by the wording. These are ones who take a very literal opinion of the writing of the Constitution, and so it's a more narrow view. An activist judge is one who is going to rule more broadly on the issue. They might even offer what we call a remedy. So not only are they ruling on the underlying principles, they are also helping to create solutions for it as well. So it's a very broad view of how to interpret the Constitution. So some judges are strict constructionists, some judges are activists, and that normally is taken into consideration when the president appoints someone and the Senate confirms by majority vote. These are other ways of looking at it. Justices are bound by the wording. Original intent, if you ever see that phrase, oftentimes they go back to the Federalist Essays and go, what was the intent of the Founding Fathers when they wrote this portion of the Constitution? Our justices' main goal is to interpret the Constitution and the meaning. So oftentimes they look at original intent. Judicial restraint, justices are interpreters, not policymakers. That sort of goes with the philosophy of the strict constructionists. Loose constructionists, considering the underlying principles, and judicial activists, activist judges, not only are we ruling on new concepts in the Constitution, but we are making policy in addition as we are interpreting. You can read this one on your own. I think that's pretty self-explanatory, and that's against judicial activism, so I'll let you go over that. All right, the last portion, what are checks on judicial power? Judges can make a decision, but it's up to the executive branch to carry it out. So really, if there's no enforcement through the executive branch, then sometimes the judge's decisions are deemed a little weaker. Checks on judicial power. The confirmation process is very strict, and it is long because they're appointed for life. So they put them through quite the test of confirmation. Impeachment, that is how a judge is impeached. The only people who can be impeached are judges and the president. Remember, Congress has their own censoring of their own members. Over time, you could change the number of judges. If you recall, Franklin D. Roosevelt, FDR, tried to pack the court and up the number of justices so he would have a little more influence on the policies that he was making. But traditionally, it has been at 9. And also revising legislation. If the judges make a rule, they can always go back and either change it and challenge those things. You can amend the Constitution as well. So if, for example, the line item veto power was overruled by the executive branch, by the judicial branch, they said that was too much power for the executive. You could go back, Congress could, and propose line item veto power for the president and add that to the power of the president. So that would be an example of amending the Constitution. Altering jurisdiction. Jurisdiction is the right to hear a case. You looked at the district map, such as Kansas City and St. Louis and Missouri. You looked at the jurisdiction area for appellate courts, which is a multi-state area. And of course, the Supreme Court would have full over the United States. So you could alter the lower court's jurisdiction. Remember, a remedy is a solution to a problem. So the courts or Congress could add restrictions on that portion as well. Public opinion in the courts, I think you can read that. That's pretty self-explanatory. And that's going to be the end. So I hope that you learned a little bit on this information, how a case gets to the court, and also how a case is heard by the Supreme Court.